The 5-day notice. Are you a property manager? What do you do if the tenant tenders payment in full after you file the forcible detainer action, but before the trial? The law says that such action reinstates the rental agreement if the tenant pays all past due rent, reasonable late fees set forth in the rental agreement, attorney's fees, and court costs. If the tenant does pay all amounts owed before the forcible detainer trial, the court will dismiss the complaint. The landlord property manager may require that the tenant pay the amount owed in cash or certified funds. If the tenant does not pay, then the court case may move forward. The landlord property manager must prove the case to the court. First, the landlord property manager should assemble all of the documents necessary to prove their right to retake possession of the premises. At a minimum, the landlord property manager will need copies or originals of the following documents: the lease, including all amendments to the lease, the 5-day notice, proof of delivery of the 5-day notice, proof of service of the summons and complaint, the records showing the tenant failed to pay rent and any other amounts owed under the lease. These records can be a receipt book, tenant ledger, QuickBooks report, or any written records or combination of records that evidence the tenant's payment and non-payment of amounts owed under the lease. The landlord property manager must also make sure that all of their witnesses appear at the trial. Usually, in a forcible detainer case, there are only 1 or 2 witnesses. One witness is a person who can testify that a lease exists. Another potential witness is the person who posted the 5-day notice. Another potential witness is the person who can testify to the court that the tenant has not paid the rent. Many times, one witness can prove all of these facts. While witnesses typically help the case, they are not mandatory. An Arizona Justice Court will typically hear a large number of forcible detainer actions and dispose of them quickly. The landlord property manager must make sure that he or she is not late to the trial. Determine the location of the court in advance and be early. A landlord property manager who has never participated in a forcible detainer lawsuit should take some time, a week or 2 before the trial date, in the same justice court, observing other forcible detainer actions. You can learn a lot from observing other forcible detainer trials. At the time of the trial, the judge will call the landlord, property managers, and defendants' names and look around the courtroom to see if anyone stands and approaches the bench. Since the vast majority of tenants don't show for the trial, the judge will only wait for 5 or 10 seconds before she looks down into the court file to review the copy of the complaint, 5-day notice, and proof of service. If the documents are present in the file, and assuming the landlord property manager or his counsel are present in the courtroom, the judge will announce a default judgment for the landlord property manager, the plaintiff, and ask the landlord property manager for a form of judgment. A default judgment means that the landlord property manager wins the case without a trial. The judge will then sign the judgment and move on to the next case. A form of judgment is a piece of paper that records the court's order in the case. It should say that judgment is granted to the plaintiff, that a writ of restitution, eviction, is ordered, that the tenant is ordered to pay rent, penalties, costs, and attorney's fees to the landlord property manager. You can obtain this form, just like the summons and complaint, at any justice court. Although rare, if the tenants appear at the trial and enter a plea of not guilty, he or she must file a written answer with the court before the trial begins. To file a written answer, the tenant must pay the appropriate answer fee required by the court. If the tenant appears at the trial, pleads not guilty, and fails to file a written answer, the landlord property manager should ask the court to issue a default judgment. After the landlord property manager wins the trial, the judge will sign a form of judgment, just like the one in the default cases, ordering the tenant to pay the landlord property manager rent, late fees, costs, and any attorney's fees. This judgment can be collected like any other civil judgment. It is often necessary for the landlord property manager to take legal action to collect the judgment. The law provides a number of remedies to judgment holders, creditors, such as garnishment of wages and attachment as a lien against any real property. The judgment obtained in a forcible detainer case should also order possession of the premises returned to the landlord property manager. If the tenant fails to return possession to the landlord property manager, the landlord property manager must obtain a writ of restitution from the court. The writ of restitution is required to remove the tenant from the premises by legal means. The landlord property manager may only go back to the court and ask it to issue the writ of restitution if the tenant does not voluntarily vacate the premises. The writ of restitution empowers the constable or sheriff to go to the premises, physically remove the tenant, and seize the tenant's property if it is still inside the residence. The constable or sheriff charges a fee for this eviction service. Arizona law provides that the tenant is responsible to pay the cost charged by the constable or sheriff. If the tenant leaves any personal property at the premises, regardless of the circumstances that caused their vacancy, the landlord property manager must immediately prepare an inventory of the property and attempt to deliver the inventory along with a notice to the former tenant. We recommend the following actions when the landlord property manager first enters the premises after an eviction. Video record the entire premises to show all personal property found on the premises or the lack thereof. If any of the former tenant's personal property remains, videotape all of it. For example, if the property is in boxes, open the boxes and video the contents. Make sure you set the camera to show the date of the video recording. Take a witness with you when you enter the premises and make the inventory. Make a written detailed inventory of all of the tenant's personal property found on the premises. The person who makes the written inventory should date and sign it.